Ms. Holler?
Good morning, Your Honors. May it please the Court, Julia Holler on behalf of the Commonwealth. In this case, this was the Commonwealth's application for further appellate review that was granted upon the appeals court reversal of the conviction entered in by a jury in this case in the lower court after a jury trial in the Superior Court. I would just begin by pointing out to Your Honors one case that came out after the appeals court opinion. The main issue below was proximate cause. It was highly contested at trial and very much open on both sides. Oh, I'm sorry. I thought there was a question on the floor.
So what's the case?
I'm sorry. The case is Delaney versus Reynolds. It's an appeals court case for Justice Peretta. The citation is 63 Mass Appeals Court 239. It came out in April of 2005, and I apologize for a copy to look at. And it talks about, pardon me, it talks about that negligent conduct is the proximate cause of the injury. If the injury was foreseeable, it was a result of the defendant's negligent conduct. In this case, what we have here is the defendant's company's just lack of putting a backup alarm on a truck that did not have an alarm.
Well, how is that operation? I mean, I have a problem with your theory of negligence here. What was the Commonwealth's theory of negligent operation?
The negligent operation was the lack of the backup alarm, which there was testimony by other drivers that the presence of a backup alarm is an issue of safety that they were always concerned about, and that a presence of a backup alarm is part of the circle check in the morning, and it's not...
So operating a truck without a backup alarm, you're saying, is per se negligence?
No, in this case, the failure to put... No, in this case, it was a jury question as to whether the failure to have the backup alarm was part of the proximate cause, because the driver...
I'm curious about negligence. What is the negligent operation? This is a statute directed against
negligent
operation of a motor.
Right, and the fact of the lack, he was operating as the agent of the corporation. The negligent operation was the lack of having the backup alarm, the lack of taking the precautions necessary, knowing that the police officer was behind him, and that the failure to maintain this backup alarm contributed to the officer's death, because it was for the jury to decide as to whether, if he didn't...
So the negligence is the failure to maintain the backup alarm? That doesn't sound like operation to me. I mean, there may be negligence on behalf of the corporation in terms of its maintenance of its vehicles, but how is that operation?
Well, but what if you drove your car and you didn't maintain your brakes, so that if your brakes went, and that was the cause of the accident? It would be a failure of the brakes, and wouldn't that be similar to this case?
Failure to maintain the equipment, the safety equipment, yes.
Actually was the cause of the accident.
It's negligent to operate a vehicle
knowing that the equipment is not in safety maintenance. Yes, thank you, Your Honor.
Is your theory?
Yes, that was the theory, is that the machine was not operating within its safety standards.
But there's no requirement that a truck like this have a backup alarm to operate in a public way as it was doing, is there?
There was not. No.
There's a requirement that you have headlights on, you operate at night. There's a requirement that you keep your car in certain safety conditions.
There was some discussion as to whether under OSHA and whether...
Ms. Haller, can we just clarify this? It was not a violation of a criminal law not to have a backup light, correct? There is no criminal liability
for the backup alarm, the failure to maintain the backup alarm. That was not, I believe, an issue below here.
Well, wait a minute. No regulatory obligation or statutory.
Wait a minute, because I have a follow-up question. There is no, if anybody is driving with backing up without a backup alarm, a truck, whatever, that does not violate any criminal, that single thing does not violate the criminal code of Massachusetts, correct?
I don't believe so.
Okay.
That was not an issue here. There was some talk about OSHA regulations and things.
Here's my follow-up question. We have a corporate defendant here, correct? Can you tell me any case in the Commonwealth or elsewhere, where the act itself is not criminal, where the corporation has been held criminally liable. So if you go to, for example, the seminal cases, the act itself is criminal, and then we look to see whether or not the person acting, is acting on behalf of, and so on and so forth, the standard. But the act itself is criminal. So my question is, can you tell me any case where a corporate defendant is held criminally liable, where the act of its employee is in and of itself not a violation of the criminal code?
It didn't say that I came up. I came up with one case where the act itself wasn't criminal, but it did allow for a cause of action, in that it became a jury question. It was a civil, but it became a jury question.
Civil. Are you talking about
But it was proximate cause.
You're talking about Fells Acre?
No, I'm talking about Rodriguez
Okay.
versus the Housing Authority, which just came down.
It seems to me, though, that this isn't he wasn't charged with, backing up without a backup light.
He's
charged with there's a motor vehicle homicide here. Somebody got killed.
Yeah, and, well, actually, the Gauthier, who was the driver, pleaded guilty to, I believe, motor vehicle homicide and failure to use care in backing up.
So nobody would be prosecuted simply, if nobody had been hit, nobody would have been prosecuted here. Correct? The criminal conduct is
I suppose if you speed and nobody catches you speeding, you're really not.
Right, but as the Chief Justice indicated, it isn't a criminal violation to simply back up without a backup light. It can become a criminal violation if, while doing so, you injure someone.
Right, and it's the
In other words, my question doesn't go to whether or not there was proximate cause.
Right.
My question goes to, and it's to me, a very serious question, because we have been very careful indeed, when we have held corporations at criminally liable. And to my knowledge, and I have looked pretty hard, I have not found any case where the underlying conduct itself doesn't arrive out of negligence or some other tort-like problem, which may result in something.
I suppose you could look at the failure to use the care and the backing up, which he did
That's
plead
not a
guilty to.
criminal violation. My concern is if you can show me a case where a corporate defendant has been held criminally liable, not because of a negligent operation or doing something which may result in the death of or a serious injury of, it might not just be death, it could be something else. And to my knowledge, I'm not aware of any such case.
The only case I can think of which talks about the criminal activities is, and the name's escaping, the Commonwealth versus the accounting firm from, it's probably close to 30 or 40 years ago now. The name is escaping me. It's the first.
The beneficial finance?
Yes, the beneficial finance.
That was a theft.
But do we really have to worry about this? Because isn't the criminal standard governed by the tort standard for negligence?
Right. It's a
So if
negligence.
there would be tort liability for negligence.
Right. It's a
as
simple
the appeals
negligence.
court points out, then there will be criminal liability, provided it's proven beyond a reasonable doubt. And
Of the individual, no question about that.
Right.
No question about
But
that.
if the individual
As
has
for the
committed the crime in the
corporations.
scope of his employment, there is...
one and the same.
Right.
Right.
Yeah.
Except, what I'm saying is that may be a possible theory, but there is no case so holding, to my knowledge.
I didn't see one in my updating.
And I've looked.
Right. The other point with that, the reason that we had taken for the further appellate review was this was a hotly contested, obviously, as it appears it's amongst you, is the issue of the proximate cause. And the Commonwealth's case, obviously, as it's marshaled the facts, is that there was sufficient evidence to create a jury question. And I would just draw your attention to, I was going to bring this in after Delaney versus Reynolds, the Daniel Vieg's testimony, who's one of the other drivers, which talks about the presence of the backup alarm and the security issues. And at Volume 1, page 178, he testified, when you hear a backup alarm, you look around for your own safety. Other than that, you just go about your own business. And that was what was at issue here. the backup alarm has a distinct tonal hazard alarm that someone listens for. And when the appeals court took it away from the jury, after the jury had manslaughter, they also had the motor vehicle homicide. When the jury took it, when the appeals court took it away from the jury, they imposed their own evaluation of the facts here, and that the way they had interpreted the facts was not in the light most favorable to the Commonwealth.
It doesn't have to be the sole cause of the accident.
No.
It can be a contributing cause.
And it was certainly foreseeable that the lack of the backup alarm, with its distinctive sound, as the truckers, these very professional, very experienced truckers testify to, that the lack of hearing a backup alarm, if you're not, granted, the officer knew that the trucks were going to be starting soon, but he's doing his job. He's directing traffic in and out of this shopping mall. That's his job. He has his back to the trucks. He doesn't know they're moving until the backup starts. He hears the backup alarm. And again, the appeals court said, well, he knew they were going to be starting, but he didn't know when they were going to be starting.
What do we make of the fact that there are lots of circumstances in which the sort of pattern and practice has been to increase safety precautions? I mean, all kinds of things. But that the legislature hasn't said you must do this. In other words, and again, I'm thinking of for criminal liability. I think the record is pretty clear here that as a general matter, this is what backup trucks do. As a general matter, this is what this particular individual did. As a general matter, that's what this particular corporation did. But there was no obligation to have this particular backup alarm, and you counterweigh that with what appears to have been extremely cautious operation of the truck in every other respect.
Except he testifies to some negligence, that he knew the officer was there behind him.
But he knows the officer's there behind him, but he's going very, very cautiously. He's looking in his back.
But he's not beeping his horn like he did the first time.
He's not beeping his
street horn.
His street horn. But your argument here for criminal liability of the corporation, I take it,
right,
is that not that they, if that was the basis of negligence, you wouldn't say that that is sufficient to impute to the corporation.
Within the framework, well, it was foreseeable that the lack to have a backup alarm, which I believe all of the drivers testified to, is an absolute, almost a necessary piece of safety equipment that they want on their trucks. That lack of that piece of safety equipment is critical.
Put it this way. I have no issue whatsoever with the civil case, with negligence,
right,
with corporate, piercing the corporate veil. I mean, the law is pretty well...
Then it's a straight negligence standard under the motor vehicle homicide statute here.
But what I'm suggesting...
But not general negligence, negligent operation.
What I'm suggesting here is that the legislature hasn't seen fit to make this even a requirement, never mind criminal liability, because, you can sometimes make the leap. And so for the Commonwealth, for the state to be saying, we're going to criminalize it this way, when the legislature hasn't done it in the more straightforward way, doesn't that seem to be a rather peculiar way to proceed? Because it essentially means that the Commonwealth can criminalize it, a district attorney can criminalize any conduct. The next time it might be, that you didn't have a red flashing light, or you didn't have a light in the, some of these cars now, if you put your brake on, the rear view lights.
The Cyclops light.
Is that what it's called?
Yes. The single?
Yeah, the thing in the middle of the back window and so on and so forth. I mean, that seems to me to be quite
an
extraordinary
within the framework of the negligent operation statute, and there was a manslaughter charge as well here, the Commonwealth, yellow already. The Commonwealth has charged with what it had, that the negligent operation, meaning the negligent use of this truck on the highway, negligent equipment, negligent driving with defective equipment, it was foreseeable that without this backup alarm at this busy job site, that someone
If you go for a motor vehicle inspection of these trucks, I'm not talking about passenger car, and you have to pass a motor vehicle inspection because the Commonwealth has laid out certain things that you've got to have. You've got to have brakes, you've got to have lights, you've got to have backup lights, you've got to have, all kinds of things. But you don't have to have this particular device, correct?
Just because it's still a question of a negligence.
No, but the answer to that is no. You don't have to have this.
Right, but it can still be done in such an, you can have a perfectly inspected
Oh, I
car, but you
understand
can
that.
still be negligent in an operation of that vehicle.
And
and
I think
get
it
into an
goes to
accident.
Then it goes to Justice Corey's question. I mean, what constitutes negligent operation? Somebody, speeding or doing whatever.
The operation of the machine with the negligent, with the improper equipment.
Well, why is it improper equipment?
Because the equipment that, and again, was the jury question.
The question is whether it goes to the jury. I don't have any...
Right. The question, and then that's the proximate cause, is whether the failure to, and the standard is whether the failure to maintain this backup alarm was negligent in that the operation of the truck, that it was foreseeable that the failure to have the backup alarm resulted in the officer's death when he was struck by the truck backing up because he did not know that it was backing up and could not get out of the truck's way. And that was the Commonwealth, in the light most favorable to the Commonwealth, that the evidence showed that this was the jury question, that it was a proximate cause of the corporation and the defendant, Gauthier, and through the corporation for which he worked, that it was this backing up of this truck without its backup alarm it was foreseeable that an accident would be caused, and that accident in backing over the Officer Erickson and resulting in his death was foreseeable.
But is foreseeability the criminal standard? Or isn't the standard operation? Don't you have to actually be the person who was committing the act in order to be criminally responsible?
Well, under LAL, Commonwealth versus LAL Corporation, it's imputed because...
No, only if the actual act
Right, but go
by
through-
the employee is itself criminal. So just to follow up on Justice Spina's question, it's the Commonwealth's position, as I understand it. Let's say backup signals were not at issue here, and there was evidence that this driver had failed to beep his horn.
Mm-hmm.
Okay? I take it that the Commonwealth would say, if the jury found that the failure to beep a horn, which could be negligent operation of a vehicle in a tort case, that failure of that agent to beep a horn would make this corporation criminally liable, because there's no dispute that he's acting in the course of his...
Right. Well, his criminal liability comes in when he pleaded guilty to the motor vehicle homicide and the failure
No, I
to use
understand that,
care.
but what I'm saying is your position, I take it in answer to Justice Spina's question, is if you didn't have a backup, in other words, it wasn't an equipment problem, it was that the driver failed, in the Commonwealth's case, to beep the horn, the regular horn, that a corporation could be held criminally liable. Correct?
Well, no, because I would just use that as part of how he was talking in answer to the due care question, so I didn't mean to imply that was something that was a substitute.
No, but assuming that you, I thought that was the import of Justice Spina's question.
I'm sorry.
I'm trying to deal with the idea of your use of foreseeability,
Right.
Which is one of the civil standards for assessing negligence. And I think that's totally appropriate when you're looking at the liability of the driver himself or herself. But for purposes of vicarious liability, I'm wondering if the legislature hasn't in fact excluded or precluded vicarious liability by making the act of operation the criminal act. You have to be the operator.
Right. But then, well...
Isn't that all taken care of by the page 606 of the appeals court opinion, which says you look directly to the civil law of negligence for
Right,
this purpose.
it's all, it is all
So
tied
if
into
the
the
driver is
negligence
acting within
statute.
the scope of his employment, which he
Right.
clearly was, and he was negligent, then
Right.
per se, the corporation
And
is
that's under the
negligent.
Wait a minute,
statute.
but you look to this, you can look to the civil law for purposes of establishing negligence.
Right.
But do you look to the civil law for purposes of establishing vicarious liability?
If
That's
he's-
a different concept.
But if he's negligent, and he's negligent, and then you look at the separate under the vicarious liability, then you can look
But
back.
only when the act, and I keep getting back, LAL, if you want to know what the facts in LAL are, is selling alcoholic beverages to a minor.
Right.
That act, by itself, nothing else.
But this is Gauthier's act.
Gauthier's act
Backing
as a
up
driver.
the truck under circumstances where the Commonwealth alleged and the jury found it was negligent to do so.
Right, and with full knowledge that he was operating defective equipment, and the company knew that he was operating defective equipment and because of the absence of the backup
That
alarm.
makes that civilly liable under ordinary negligence law, and it also makes it criminally liable, in my opinion, if the Commonwealth can persuade the jury beyond a reasonable
Right.
doubt.
And there was no question, there was no disagreement over
And by the way,
proximate
did
cause.
anyone raise this other point that we're talking about today in either the trial court or the appeals
I
court?
don't believe so. Mr. Corp may be able to,
Was
not
it
to
the
put him
whole-
on the spot, he was the trial attorney.
Well, he can answer for himself.
So
if not-
by looking through the transcript, I don't recall
If
seeing
not,
this.
isn't it out of the case under,
Well, proximate cause,
Never out of the case in the criminal case.
proximate cause was such a hotly contested issue, although there was never any contestation, if
no, but
that's a
this
word,
is
but
not,
that he was not an employer, he was
This-
acting ultra vires
this
or
is not
anything of that matter.
proximate cause is in the case.
But, or
The
the
question we're talking about now is whether the
master and servant
Vicar-
liability, for
you're
lack
right.
lack of a better way to describe it. No, that was not at issue, is whether he was acting within his authority or working for Angelo Todesca at the time. And the Commonwealth did set up, through its witnesses, that there were several corporations, but that they all worked together and that he was an employee working for Angelo Todesca at the time of this.
But in your view, then, forget the homicide. In any case involving negligent operation of a motor vehicle, Chapter 90, Section whatever it is, 24A, the same section that has the drunk driving. Under the negligent operation of a motor vehicle, the criminal negligence of a motor vehicle, any employer would be vicariously liable, criminally vicariously liable for the acts of its agent or employee that was criminal, if the person was acting within the scope of their employment.
If they're acting within the scope of it,
Well, there must be cases, I mean, if a
There was-
taxi cab driver kills somebody,
I
there
was-
must be a case
I was
on
just
that.
thinking there was a case.
There are
and
no
I-
such cases because it is a requirement to hold a corporation criminally liable that the act itself, not the negligence, but the act itself, you sell to a minor, you steal property, you falsify records, the act itself. And
Yes, but the act itself would be criminal if the taxi cab driver is operating under the influence or is operating to endanger. That's plainly a criminal act.
There was a case that just came down, and
Could be
it does
if that's-
involve a taxi cab case, and I have it over here, and I can't think of the name of it, but it might have been a civil case. I was doing some
So
research
if
yesterday.
the taxi driver is operating under the influence of alcohol,
Right.
that is a criminal act.
Gauthier-
And therefore, if you could show, which you could show in some circumstances, that the corporation knew that this man, that he had showed up at work, that he had alcohol in his breath, that, whatever it was, then you get into that, and that's exactly what beneficial finance
talks
did
about.
and what LAL did. Very important.
Gauthier would have been entitled to a trial on that motor vehicle homicide aspect and the failure to use the care and backing up. Instead, he pleaded guilty to both the motor vehicle homicide and the failure to use
Sure.
care and
No, I
backing up.
understand that.
There was the criminal conduct, the negligent conduct. And that, in turn, the Commonwealth could use to move, not bootstrapping, but certainly it would be allowed to then move to present its theory to get to the jury, to present its theory of proximate cause in the light most...
So you're saying because Gauthier pleaded guilty to operating negligently, there's the criminal act that the Chief Justice is acting
Well,
on?
it's all the negligence. He was driving. You can't as finally separate them out.
But we
here.
have.
But I don't, with all due respect, I don't think you can finally,
No, I
finally
understand.
separate them
All I
out.
was saying is, find me the case. Find me the case.
Right,
And it may be that we decide to extend
Right.
beyond anything that we've done before. All I'm saying is, it's a very,
Right.
it's a dramatic departure from what our jurisprudence has been before. It may be appropriate in these circumstances.
And I would, if I know we're way over here, and I would just like to finish by just saying that we've gone way far afield of the appeals court opinion, and our why we disagreed with them was that they accepted the framework within which we were working, and which certainly is actually their duty to accept the framework with which they have been given. But our beef, if you will, with them was that they had usurped the jury's function, and that was mainly where we were. And I will obviously submit the other issues on my brief. Thank you.
Thank you, Ms. Hona. Mr. Corp?
Good morning. My name is Jeff Karp, and I represent the corporation, and I was trial counsel. A couple things that I need to just correct. Gauthier did not plead guilty. If you look at footnote, I think it's 9 of the appeals court decision, he admitted to sufficient facts, got a continuance without a finding. He did not plead guilty. The other...
I take it that wasn't in evidence one way or the other, was it?
I believe it was for... my memory is that it came up on an impeachment type of
Gauthier
issue.
himself testified, I take it?
Yeah,
Okay.
yes, he did.
Okay.
Yes, he did.
Well, wait a minute. So it was in evidence for purposes of it was that he did plead guilty was in evidence?
No, he did. No, what the evidence was, and I can't remember if it was for impeachment purpose, if there was a limiting instruction.
But if he didn't plead guilty, how is it relevant for any purpose?
It was a matter. My memory is it was a matter of trial strategy. I don't remember the specific reason. I don't believe that I objected to the admission into evidence of the continuance without a finding.
That he was testifying this way against a backdrop of being granted a continuance without a finding. Yeah,
Right.
okay, that's fine.
I mean,
Could I ask you to address your theory that this is negligent maintenance and not negligent operation? I mean, Gauthier is unquestionably operating the vehicle, and he's operating it with knowledge of what equipment it has, what it doesn't have. He's operating it with knowledge that there is an officer back there. He's required to use due care in all the circumstances.
But
why isn't that operation? The fact the thing that causes a problem is the lack of a piece of equipment, which you could call maintenance. He knows the equipment is not there. Therefore, that's one of the circumstances against which that he must now take into consideration in the manner that he then operates the vehicle.
If I can make 2 points. One is that this is a criminal case, and the criminal statute needs to be strictly construed against the Commonwealth. It says whoever operates a motor vehicle, ... It doesn't say whoever fails to equip.
But then I raise my question.
He's still operating the vehicle.
Yes, he is.
And among the circumstances that he knows, among many circumstances, is there's an officer back there. Backup alarms are normally used at this construction site and at most construction sites. Therefore, the officer who doesn't know that I don't have one, is probably expecting that that's going to be the signal. Gauthier operates the truck knowing all of that, and why can't a jury decide, well, that to just back up, knowing that you've got a blind spot, knowing you don't have the alarm, knowing that the officer's expecting the alarm, in all of those circumstances, that does not satisfy due care. Therefore, it's negligent.
Because in the facts of this case, even knowing that that Gauthier didn't have a backup alarm that wasn't required by federal law, wasn't required by state law, wasn't a factory-equipped piece of equipment, and this was the evidence, was never installed on commercial-grade trucks at the dealer level. The U.S. Department of Transportation annual inspection report, which was submitted to the...
But there was plenty of evidence that the expectation of people at such a site is that trucks normally will have this equipment, and therefore that's how they behave. That's how the officer would behave. He would expect to hear it. I mean, let me give you a hypothetical. If instead of doing that, if Gauthier had gotten out of the truck and had promised Officer Erickson, before I back up, I will lean out my window and yell at you that I'm about to. So he's created this expectation. Here's the warning you're going to get. There's no federal requirement or any other requirement that you lean out your window and yell. But if you've told the officer, that's what I'm going to do, if you've effectively communicated, that's what I'm going to do, then the officer is reasonably relying on that. He doesn't lean out the window and yell. He backs up, he hits him. Why can't that be negligence?
Because in this case, even if we assume that Gauthier, even if we assume that the absence of the backup warning alarm was self-negligent, the operation, again, in a criminal case, Gauthier's operation was 4 witnesses, 2 to 3 miles an hour. One witness said that the truck was going as slow as a truck could go and still be moving.
Well, then I'm going to ask you my question again. What about if you carry your argument to the extreme, then somebody who operates a car without brakes or with faulty brakes is all he's doing is driving, he's not liable because of the accident because it's only negligent maintenance and it's not negligent driving?
But it depends on the facts of the case. If the driver was doing things in order to make up for that. Number one...
Well, suppose he was using his handbrake. He's using his handbrake instead, and he's very good at it. But he's driving without brakes. You would argue that that's simply negligent maintenance and not negligent operation?
Because there's a requirement that you have operating brakes. There's the endless requirements that you have operating brakes.
See, I think the problem here, and I have to agree, is that you can't isolate, again, because this is a criminal case, you can't isolate one aspect of this case. And the facts of this case, this driver, even without the backup alarm, even if federal law required it, operated this vehicle in a reasonable, non-negligent manner. Without that negligent operation...
Wasn't that a fact question for the jury, though?
That's a fact question.
That's a fact question. No matter how slow you're going...
It may be a fact question for the jury, but that's what we have appellate courts for, to determine whether the jury got it right. They didn't get it right because even looking at the inferences in the light most favorable to the Commonwealth, there was nothing that a reasonable person could think this driver did or didn't do in backing this truck up when he and 2 other truck drivers warned this officer. And we have to keep in mind here that...
That's a different issue. Can I approach this from a little bit of a different angle? Would you agree with me that the civil standard of negligence applies here? That's in the appeals court opinion. Well, is that the law?
It is the law. It is the law. Although the statute does say negligent operation so as to endanger human life or safety.
Well, now, stay with me for a moment. Okay. Now, there's evidence apparently that the federal government, the state, the motor vehicle laws, all kinds of other things, don't require an alarm on this type of truck, right?
Correct.
Okay. Now, the Todesca Corporation decided it was going to put an alarm on this truck.
Correct.
Okay. Have they not, by doing that, assumed a duty, independent of any requirement by law, to make sure that alarm was not only on the truck but operable?
I'd say no.
Why not?
Because, again, because they're not required to do so.
Right, but if people at the work site where Todesca is working, again, Todesca has done this. It has contributed to or created the expectation, this is how we're going to warn you. Maybe they're not required to use that form of warning, some other form. But if they've said, here's the way we're going to warn you that a truck is backing in your direction, and then they don't give that warning, haven't you? You've assumed a duty to warn in the manner you have led people to rely on.
And there are hundreds of cases that say that you can assume a duty higher than the law requires you to do by your own voluntary act. That's in the Restatement of Torts. It's everywhere.
But did the operators?
But I would suggest that if that duty was assumed, the driver, Gauthier, did more than what was required by that duty
that's a different issue.
But, okay.
Put it this way, you can assume a duty. To whom do you assume the duty?
Well, I guess you assume the duty to everyone working at this construction site, but the fact of the matter is that this was a police officer that was working a paid detail whose job it was to supervise this area of this closed roadway. And we haven't even gotten to the issue that the evidence was that the portion of this road where the impact happened was closed to the public, according to Thomas Ockerbloom, who was the Massachusetts Highway Project engineer who was out at the site that morning, who actually closed this portion of the roadway. This wasn't open to the public.
Let me go back, though.
what?
Because that's one of the elements of this criminal offense, is that it happened on a public way.
That Gauthier could have disavowed that duty very simply if he had warned the officer or others around, guys, my backup alarm isn't working today. You're going to have to watch my truck more carefully.
Well, but I assume...
I mean, he could certainly have done things to, just so that people weren't relying on an unrealistic expectation. Unfortunately, he didn't happen to do those.
But the evidence was that he had been there earlier the day, backed up the truck, the alarm wasn't working, so it's not like... And the truck had been operated this way for 2 months.
And this was his third trip with
Asphalt.
Asphalt, thank you. With asphalt to that site that day. And again, it was, well, again, we're dealing with a police officer, and I think that we need to, and I'm not trying to blame the victim by any means, but it's very important in this case that this was a police officer who was working a paid detail, whose job it was to supervise, who was told, it wasn't like it's a pedestrian that was driving by that may have been inattentive and said, I'm going to be backing up your way. These three truck drivers told this police officer whose assignment it was to supervise the area at which he was struck.
You're arguing contributory negligence, which has no place in a criminal prosecution.
Well, contributory negligence doesn't, but there is case law that says that one of the things that the Commonwealth needs to prove is that the officer's sole negligence wasn't that the officer's negligence wasn't the sole cause of the accident.
No, that's causation.
Exactly. And what I would suggest to you is that if we get back to the causation angle of this, we need to look at, step in the shoes of that officer and what his responsibilities were. And he had his back to the area of the roadway that he was supposed to supervise.
A jury issue, and they found against you.
They had it wrong, though. They simply had it wrong. In my estimation, well, I can't speculate as to what the jury did, but
was the defendant charged with what I'll call the old common law manslaughter as well as the vehicular homicide manslaughter?
Yes, and it was...
So all these common law concepts make their way into this case through that charge.
Exactly.
And he was... The corporation
You're talking about the individual or the corporation?
No, the corporation was charged and was acquitted of manslaughter.
It was acquitted of manslaughter.
And the issue, in my estimation, that the issue of the backup alarm is actually a red herring as it applies to the vehicular homicide statute. It's very important, or it has some importance on the manslaughter end of it, because there isn't an operation, there isn't a statute that's strictly construed. And, again, I can't speculate as to why the jury did what it did, but that is what you folks are in the appeals court.
There was a better case for manslaughter than there was for vehicular manslaughter against the corporation. Perhaps, yes. I thought that, personally, that the case was weak on the manslaughter as well, because the standard of wanton or reckless conduct, and again, you have to get back to the fact that the backup alarm wasn't required, and et cetera. But yes, but I think that the Commonwealth bootstrapped the argument of negligent maintenance onto the manslaughter charge, and that, again, and I hate to keep
beating the same point here, but this is a criminal case, and it is, the statute says operation, and I agree. I agree that if the brakes were a failure, that would be one of the things that we're talking about. But if you still look at, even with the absence of the backup alarm, if you look at how this driver drove, it wasn't negligent. It wasn't close to negligent.
But isn't that a jury question, Mother? Unless there's not evidence to support the verdict.
Right. And that's what the point here is that the jury just got it wrong. They got it wrong. The Commonwealth did not meet its burden in this case. Thank you.
Mr. Kopp.